You know what, Pierre, I have an idea that when you come up with something that you would like our audience to know about, you could send me an email, and I would email it to everybody in the audience. So everybody is up on whatever is the late-breaking news, but from your point of view. And so, and then we could do the same thing with Leslie as well. Okay, Leslie, tell us what's happening on the Hill. Yay.
You know, I was at the office last night late because I was feeling very insecure because my topic is what's happening on the Hill in my area. And I got to be honest with you, bupkis. I mean, you are not going to see anything in labor and employment area with the exception of immigration and, I don't know, maybe some healthcare. And, you know, as of yesterday, I was following the immigration guy and the healthcare guy, and I was like, well, they're not going to care what I have to say. So what's happening in the Hill? Well, we have an inauguration on Monday, and my office is on Pennsylvania Avenue, so we get the stands outside it, and everything shuts down. Really, honestly, except for small issues or if something happens to come up, you know how things come up, I wouldn't anticipate any new legislation this year. What you are likely to see on the Hill, on the House side, because it's Republican-controlled, is oversight. And in the short term, you're going to see House oversight over the National Labor Relations Board. They're going to be scrutinizing in a hearing, I think, pretty shortly, what the National Labor Relations Board has been doing with regard to what constitutes concerted protected activity, because there's been a series of recent decisions, which I call when labor law swallowed employment law, because they're finding things like if you are conducting a workplace investigation and you tell employees to keep the information confidential because you don't want it to screw up the investigation, that you could have interfered with that employee's right to engage in protected concerted activity. And this applies to union and non-union employers. But this same theory is also being used in handbook provisions and in social media cases where employees say things over social media. Now, while I'm really actually planning to focus most of what I want to talk to you about today on another agency, my former agency, the EEOC, I want to mention one last NLRB issue because I think it really gives you a flavor of what, you know, what types of things you may see inside the Beltway during the second Obama administration. The National Labor Relations Board is supposed to be a 5-member board, but a couple of years back, it only had 2 members, and it kept on making decisions, and the Supreme Court ruled that it had to have at least a 3-member quorum to do that. And in fact, the board does actually have 3 members right now, but 2 of the members were recess appointed, and there's been a challenge to their recess appointment, and from what I understand, you know, there's some reasons for the challenge. So there's a possibility, it's sitting in the D.C. Circuit, that the court could rule that those 2 members weren't properly appointed, in which case we'd then have 1 member of the board, except that member's term is up in August, and I'm also hearing that it's extremely unlikely that anyone's going to be conformed to the board. So this year we could really possibly see a situation where we have no members of the National Labor Relations Board at all, only a general counsel who really can't do much without a board. And I guess that would put the end to the oversight hearings. So it's impossible, you know, it's not definite, but it's just kind of interesting. Now, I'm going to move on to an agency I know a whole lot more about, and I was busy scribbling things, and I don't know if you explained, I was at the EEOC from 2002 to 2008. I was commissioner and vice chair there, and I, you know, have a lot of very positive feelings about the agency, but I also get frustrated, just like you guys do with your jobs. There's things I love about it, there's things I don't. I very much believe in its mission, and when I talk about it, sometimes I think when I'm outside the Beltway, people think I'm being partisan. I'm not. I'm sort of talking from a management perspective of, you know, how do we deal with these? I understand the point behind them, but how do we deal with it? Now, In late December, the Commission voted to approve its very first strategic enforcement plan and released the plan publicly. Now, what I would typically advise my clients is to pay very little attention to anything that's a public government plan, and I have to admit that I really paid much attention to these. I found them to be kind of overly bureaucratic when I was in the government. But I'm going to focus on this plan today because I have a really good reason to believe that this document could actually be quite different. First of all, it's a byproduct of a multi-year effort led by EEOC's chair, Jacqueline Berrien, and two pretty influential commissioners, Feldblum and Lipnick, and a group of really key career employees from around the country took an active role in developing the systemic plan, strategic plan. It's intended to function as a blueprint for the EEOC's enforcement activities over the foreseeable future. Now, if your company's had to deal with the EEOC charges, I believe this document calls attention to nearly all of the hot-button issues that are worthy of your attention. It lists 6 rather broad enforcement areas, and what the agency has basically said is that meritorious charges, and that we could talk about when charges are meritorious for hours. We're going to skip that part for a moment. But raising any one of these issues will receive focused attention from the EEOC's investigators during the investigation stage and lawyers for possible litigation. Now, one of the oft-repeated themes throughout the SEP is that the EEOC lacks the resource it needs to investigate, let alone litigate, every potential case of discrimination. Last year, in terms of litigation, the Commission filed only about half the number of cases it normally files. Now, many of those were systemic cases, which is the EEOC's term for class action cases, because the agency had moved towards doing more of those. But nevertheless, there's a lot less cases. At the same time, the number of private discrimination claims has escalated in a huge way over the last few years, and the agency's budget has not. While it got a significant bump at the beginning of the Obama administration, last year the agency had to cut $6 million from its budget, and this year it was flatlined, and now with the sequestration and the whole budget cliff debates, all agencies are being cut additionally, which means they really have less people to investigate charges, and the charges still come in the door, so they have to find a way to better manage the charges and to figure out what they're going to focus on. So essentially the SEP provides that that if an employee files a charge that contains any of the allegations falling into these hot button areas, they're going to throw more resources at those charges and possibly litigate them. And in fact, it instructs the district offices to investigate and pursue non-priority cases only where, quote, resources permit, and clearly that's not going to happen. I'm not saying every office is going to follow this to the letter of the law, but they generally do try to follow the mandate of the Commission, so that's why I think it's so important. So what are these issues? Well, one is discriminatory class-based recruitment and hiring. Now, this is not new. As I mentioned, EEOC has been focusing on systemic cases for a while, and barriers to hiring and recruitment has been huge over the last few years. The EEOC focuses on this area because it believes it's in the best position to uncover and remedy systemic discrimination in hiring, because an employee doesn't know why they weren't hired. They don't know who was hired instead. They're usually not in the workplace. And so there's usually less charges there. And also the EEOC has its own unique tools to get to hiring discrimination. I can file commissioner charges. It has broad investigatory authority and extremely broad subpoena authority. So the SEP makes clear they're going to continue to go after class-based recruitment and hiring that intentionally discriminate or more likely have an adverse impact on a particular group, such as racial, ethnic, religious groups, older workers, women, and people with disabilities. So such practices would include channeling or steering individuals into specific jobs based on status in particular groups, restrictive application processes, the use of screening tools such as pre-employment tests. I think you're going to see a lot more in the testing area. Background checks or date of birth inquiries. Now, with regard to background checks, there's something in your material. The Commission issued a new guidance on background checks. You know, those of you who work in New York, you already have pretty strict laws, but EEOC is very interested in background checks. They filed a few cases. They haven't really won one yet, but they're still pursuing it very hardcore, and they're going to continue to do so. I hear they're going to be filing cases in the short term. Beyond criminal background, they're also can't stand when employers use credit checks. They do not understand how credit checks could be valuable in employment situations. And if they had their druthers, they would outlaw it. But, you know, as it happens, another federal agency actually has authority for it. It actually moved to that new agency. But they came remarkably close last March when they issued the criminal background check to issue a guidance that would have talked about, you know, when you could use credit checks. And it would be in extremely rare circumstances. I mean, I heard from one person in the agency that even a chief financial officer it might not be necessary for. So I just wanted to give you a flavor for that. One thing that did stand out in the strategic plan, this first one, is these date of birth inquiries. I know that happens sometimes on applications that you need it or you need it for verification, but I would definitely separate it out from what the decision maker sees. And if you don't do that, I mean, it's kind of an easy one for the agency to go after, but I hadn't really seen any cases up to now. The second issue is that the EEOC is also going to target job discrimination, target disparate pay, job segregation, harassment, trafficking, and discriminatory policies affecting immigrant, migrant, and vulnerable workers. This is another place the Commission really sees its mission as very important. You know, the vulnerable populations, the immigrants are not native English speakers. They don't know about their rights under our laws. And so the Commission really sees that they have a role. And in the past, they've kind of jumped and been very creative with national origin discrimination claims to get to some interesting situations, such as a group of employees from Southeast Asia who were promised jobs and then locked into a factory. I mean, literally. And they got to them. I don't think, you know, we have situations like that here in New York, but this is a time where they will step in and get involved. The third area is emergent areas of the law. Now, as the only federal agency devoted exclusively to eradicating discrimination in employment, the EEOC has always sought to be on the cutting edge. Like, what is the new discrimination issue, and how can we get at it? And the SEP, the good thing about it is that it actually lists what, at least in the near term, the Commission feels are emerging issues. Now, some of them are more obvious. The Americans with Disabilities Act and the Amendments Act was passed. And so, as a new law, they really want to expand coverages if it's not rather expansive now. I think you're going to see a lot more challenges on reasonable accommodation issues. I mean, if you look out there, there isn't as many as you'd think. They're going to continue to go after employers who have inflexible leave of absence policy. You want to go back, if you do nothing else, if you hear nothing else today, and look at your leave of absence policy. If it's tied to short-term disability and it says if the person goes beyond 6 months, you know, they're out, please change it just to say, put some flexible language in it. I mean, because this is something they're going after, because they're saying if you are cutting off somebody at a particular time that's set in advance, then you are not doing an individualized assessment and you're violating the ADA. They're also going to probably go after issues having to do with people with mental disabilities or alleged mental disabilities, so behavioral issues and reasonable accommodations there. And you're also going to see things on qualification standards as well as undue hardship and direct threat. A huge issue this year is pregnancy. Accommodating pregnancy-related limitations under the ADA There's a legal question as to whether pregnancy, which is short in duration, actually qualifies as a disability. That's why it's an emerging legal issue. I would say that if you have a situation that's on the line, I would definitely accommodate the person, because just the fact that you're not accommodating somebody and they're pregnant, they're going to try to make new law to make this clear that it is covered. And finally, the Commission is planning in the emerging area to pursue cases that would extend the coverage of lesbian and gay, bisexual, and transgender individuals under Title VII. They're saying when you don't hire somebody because of sexual orientation, then it's because of sex, and that's, the theory there. The fourth area is compensation systems and practices that discriminate based on gender. There was a big task force during the first Obama, term. The agencies were all supposed to be working on this issue and what could they do, and we've seen remarkably little out of the EEOC. I know from my time there that this is an issue that the agency really cares about, but it doesn't do a particularly great job from an enforcement perspective of getting to it. I can tell you that here in New York, Elizabeth Grossman, the regional attorney, is passionate about these issues. Now, last year, it was revealed that several EEOC district offices, including here in New York, the district office, were conducting a pilot project using directed investigations as a mean to approach and audit employer pay practices, even without a prior charge of discrimination. A directed investigation can be filed by the district office. They don't need a charge to come and investigate. And what they were doing was sort of making it into an audit-type situation. But what I had heard, through the grapevine is that it hadn't really been all that fruitful. And yet, when I look at the SEP, it specifically mentions using directed investigations and commissioner charges, which you would use under Title VII. So this means, to me, that EEOC is going to continue this line. So you may, see more of that, directed investigations, but you definitely will see something from the Commission in the compensation area. And claims with compensation discrimination, particularly mid and high level female employee issues, those are big and take them very seriously. The fifth is preserving access to the legal system. The EEOC does not like employment policies and practices that discourage or prevent employees from seeking legal recourse for discrimination. Now, of course, the first thing that comes to mind is retaliation charges. And even though those have surpassed race charges to be the #1 most often filed charge with the EEOC has a vested interest in retaliation. And what I used to say when I was at the Commission is because if people are afraid to file charges with the EEOC in the first place, then they will never know about discrimination and they can't do their job. But I recognize at the same time that now it's the #1 charge. They can't investigate and litigate all of these at all. But I would still continue to be overcautious, overemphasize what you do, because the cases in this area of the law are particularly easy to prove. And you're in HR, you don't have to be guilty of the underlying discrimination to still lose the retaliation. So, it's just an area you have to be overly cautious about. In addition, I'd be cautious about the language you use in your waivers and settlement agreements, because the EEOC is going to go after employers, to continue going after employers who require employees to sign overly broad waivers, or if you include a provision in a settlement agreement that prohibits employees from filing charges with or cooperating with the EEOC, you're going to have an issue. I don't know if any of you have had the situation here in New York where you've had a charge filed and then you've settled the charge with the employee and you've tried to withdraw the charge from the EEOC. In New York especially, elsewhere sometimes, they always demand the settlement agreement, and that's because they want to look at the language in the settlement agreement to see what it says. Everyone's afraid to give it to the EEOC because they say, I don't want them to see how much I settled this charge for. And they do look at that because they roll it into a report that they file of how much money was collected. But what Elizabeth Grossman, and I just did a 2 years ago I did a New York EEOC TAPS with her, and it was all about this. They are scrutinizing these provisions. So you really want to make sure that your provision does not have language that's going to bother the agency, because, they will do something about it. Finally, I just wanted to mention the last one, which is systemic harassment. And I think that this issue is interesting for what it isn't. Systemic harassment, as in class action harassment. What I read from this and what I know from my time in the agency is there was a belief that it was pretty easy to see and go after individual harassment claims. And, you know, they could find a bazillion of them, is what they're saying. And so, especially for litigation, they're really looking for more class-based vehicles than single action harassment. Now, the exception to that is, and how does somebody phrase it? If there's an aggravating factor. So, what do they mean by an aggravating factor? You know, really heinous facts. Particularly heinous facts, a teenager involved, rape, something like that, that all bets are off. They'll probably still really invest time and resources into investigating and will, you know, more likely litigate. But for the most part, this plan signals to me that they're going to spend a lot less time on individual harassment. What they are going to do is do an investigation, and the extent of what these investigations are going to look like, they're still working out, I think. And then they're going to have a more robust referral program to plaintiff's attorneys. So, again, harassment, even single plaintiff harassment, is still to be taken seriously. Beyond EEOC, I just wanted to mention a couple of issues at Department of Labor. But before I do that, how many of you are government contractors? Okay, just a few. All right. If you're a government contractor, you should be warily anticipating 2 new regulations that were in the final stages of the rulemaking process last fall. These new regulations are intended to bolster federal contractors' recruitment efforts and employment of individuals with disabilities and veterans, which are both very well intended and warranted. I think these are areas where we see significant unemployment, and that, you know, they're important, but unfortunately the devil's in the details. They'll require contractors to ask every single applicant for employment to self-identify as an individual with a disability on the application and again later in the process. They'll require contractors to survey their entire workforce each year to ascertain disability status. Now, I don't know about you, but my clients, unless somebody needs to be accommodated, they don't want to know about someone's disability. I mean, they really don't, because once you know, you can be held to discriminate against them for the disability. But if you don't know, how could you discriminate against them? So this is a bit of an issue. I mean, I'm sure they're going to try and find ways to separate out the information, but it's kind of like a wellness exam. Even though most people don't know with anything to do with wellness, there's this feeling that once you've told Big Brother, everybody knows. So it's extremely problematic. And the final burdensome aspect of the rule I wanted to mention is that it'll require employers to track every reasonable accommodation request, no matter how informal. Now, there's always a formal process, but there's those other things that happen in the workplace where it's orally agreed, and it's going to be pretty hard to capture that. Lastly, I wanted to mention what they're doing in veterans. It's more in the recruitment area. They're going to require federal contractors to conduct more substantive analysis of their recruitment and placement actions, and they're going to include numerical targets to measure the effectiveness of the efforts and pretty strong record-keeping requirements. So that is what I wanted to let you know about, what you can expect from Washington, and thank you.